Guys, we have some breaking news related to bump stocks, and the Sixth Circuit U.S. Court of Appeals just rendered an opinion, and you're going to want to see it. Before I do that, I want to thank the sponsor of the video, and that's the United States Concealed Carry Association. USCCA is a ton of training and education for members. When you become a member, you also get self-defense liability insurance, so God forbid you have to protect yourself or others. You'll have somebody that'll help protect you in court, because I don't know about you, but I'm not sitting on $1 million for a legal defense, and USCCA will have you covered. Check them out, uscca.com/GNG. Let's get into this breaking news out of the Sixth Circuit. This came down about, an hour ago. The decision was dropped by the time I'm done recording this. And this decision strikes down the Sixth Circuit District Court ruling. And this decision says that the bump stock ban is no bueno. Check this out. The case in question is Scott Hardin versus ATF, and this is a case out of Kentucky. And the three judges chiming in on this are Judge Gilman, who delivered the opinion of the court, with Judge McKeague and Judge Bush also delivering separate opinions concurring with the judgment. Let's jump right to the opinion. Ronald Lee Gilman, Circuit Judge. The placement of a bump stock on a semi-automatic rifle causes the rifle to function essentially like a machine gun by dramatically increasing the rate of fire. And the possession of a machine gun is a criminal offense under the Gun Control Act of 1968. This raises the question of whether a bump stock is a machine gun part as defined by the National Firearms Act of 1934. The question is a close one on which reasonable jurists have disagreed, a disagreement caused by the ambiguities in how the applicable statute defines the term machine gun. An act of Congress could clear up the ambiguities, but so far, Congress has failed to act. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, has been on both sides of the issue, with its current regulation, the rule banning bump stocks as a machine gun part. In this situation, the rule of lenity that is applicable to criminal offenses requires us to rule in favor of Hardin. We therefore reverse the judgment of the district court and remand for further proceedings consistent with this opinion. In layman's terms, what does it mean? Because this rule by the ATF has criminal penalties for law-abiding citizens, then they must grant lenity to the people. That's us, meaning this rule is unconstitutional because ATF does not have the power to create law that has criminal penalties assigned. They can't create law anyway, but they can't create law that will cause criminal penalties upon the people. And that's awesome. I'm going to show you a little more of this and show you how they came to this decision, because this is going to be key, because I believe the bump stock case is going to end up before the United States Supreme Court. So check it out. For over a decade, the ATF, to which Congress has delegated the authority to administer the National Firearms Act and the Gun Control Act, maintained that a bump stock is not a machine gun part. Sound familiar? Sound like the pistol brace rule? That's why we're going over this, guys. But in 2018, after a gunman in Las Vegas, Nevada used bump stocks, allegedly, attached to semi-automatic rifles to kill 58 people and injure roughly 500 more in the span of approximately 10 minutes, the ATF reversed its position by promulgating the rule. The rule gave possessors of bump stocks 90 days from its effective date during which to destroy or abandon their bump stocks, after which they would be in violation of the Gun Control Act's prohibition on machine guns and their parts. The appellant in this case, Scott Hardin, owned several bump stocks. Following the ATF's promulgation of the rule, Hardin brought an action in the Western District of Kentucky challenging the rule as exceeding the ATF's statutory authority. The district court granted the ATF's motion for judgment on the administrative record. Hardin now appeals. I want to show you now the analysis, and this is how the judges are thinking to get to what they decide. And I want you to see this because this is good, and we're going to see it again with the pistol brace rule. Mark my words. Whether a bump stock is a machine gun part depends on how one interprets the definition of a machine gun as set forth in the National Firearms Act. In particular, the dispute focuses on the words automatically and a single function of the trigger. Those courts of appeals that have faced the issue are divided on the answer, and the Supreme Court has not weighed in. On one side, saying that a bump stock is included with the definition of a machine gun, are the 10th Circuit and the DC Circuit. The opposite view is taken by the 5th Circuit, and that's the Cargill case. And our own circuit is split down the middle with 8 judges voting to uphold the rule and 8 judges voting to strike it down. And that's the Gun Owners of America case. A total of 22 opinions are set forth in the above cited cases, which fully explore all aspects of the issue in nearly 350 pages of text. We therefore have the benefit of being able to draw on our own conclusions from these erudited opinions without having to repeat them verbatim. A. The weight of authority concludes that the definition of machine gun is ambiguous as applied to a bump stock. Hardin argues that the statutory definition of machine gun ambiguously excludes bump stocks, whereas the ATF argues that the best reading of the statute compels the opposite conclusion. Without repeating the intricacies of those positions here, there can be no doubt that a significant number of reasonable jurists have reached diametrically opposed conclusions as to whether the definition of a machine gun includes a bump stock. The viability of competing interpretations is exemplified, not only by the myriad and conflicting judicial opinions on this case, but also by ATF's own flip-flop in its position. And because the statute is subject to more than one reasonable interpretation, it is ambiguous. They then talk about Chevron and how it is not applicable in this case. And the third part here is the rule of lenity and how it requires them to rule in Hardin's favor. This brings us to the rule of lenity, under which penal statutes are to be construed strictly. Therefore, when Chevron deference is not warranted and standard principles of statutory interpretation fail to establish that the government's position is unambiguously correct, we apply the rule of lenity and resolve the ambiguity in the criminal defendant's favor. In sum, it is not enough to conclude that a criminal statute should cover a particular act. The statute must clearly and unambiguously cover the act. And that came up in the Cargill case. Judge Ho's concurrence in Cargill directs our attention to 2 persuasive analogies. The first concerns designer drugs, which, although just as lethal as drugs prohibited by the Controlled Substances Act of 1970, differed in chemical composition. Yet, all 3 branches agreed that existing law did not ban designer drugs, requiring Congress to enact the Controlled Substance Analog Enforcement Act of 1986. The secondary analog concerns the facts of U.S. versus Wiltberger. In that case, the Supreme Court unanimously construed a statute that punished manslaughter on the high seas not to apply to an identical act on a river. The court noted that it was extremely improbable that Congress would want to treat upstream manslaughter differently from manslaughter committed downstream past the river's mouth. Even so, the Supreme Court ruled in the criminal defendant's favor on the basis that probability is not a guide which a court, in construing a penal statute, can safely take. Bump stocks may well be indistinguishable from automatic weapons for all practical purposes, but they're not. But it would be dangerous to punish a crime not enumerated in the statute because it is of equal atrocity or of kindred character with those which are enumerated. Because the relevant statutory scheme does not clearly and unambiguously prohibit bump stocks, we are bound to construe the statute in Hardin's favor. The conclusion: for all of the foregoing reasons, we reverse the judgment of the district court and remand for further proceedings consistent with this opinion. Now, I will link this decision in the description for you. This is big, guys and gals. Bump stocks, we know this. We've been talking about this for years. Donald Trump pushed the Justice Department, the DOJ, to ban them. The ATF did what they were ordered to do, just like Joe Biden's pushing them to ban frames and receivers, pistol braces, get rid of as many FFLs as possible. Oh, by the way, about those 3, Steve Dettelbach, the director of the ATF, will be before Congress tomorrow testifying in an oversight hearing on the ATF. I will have that live. Link is going to be in the description and pinned above. Join me tomorrow at 9:55 a.m. live to watch Steve Dettelbach squirm, as he's called on the carpet. But all of those things are being pushed administratively. They are not in any of the laws that Congress has put on the books. Therefore, the ATF has stepped outside of its statutory authority, and in this case, The bump stock ban was struck down and remanded back to the district court. We'll see what happens back down in Kentucky, and I will keep you in the loop. If you want to stay in the loop, then subscribe to Guns and Gadgets down below. This channel brings you Second Amendment news every single day, whether it's good, bad, ugly, or indifferent, no matter where it happens in the country. I will bring it to you, and I appreciate you, each and every one. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all on the next one. Take care. See you tomorrow in that live stream.